Hey, it's Rob, and I want to talk a little bit about the regulatory landscape for artificial intelligence. Maybe you're thinking, wait a minute, AI's so new, and people haven't actually even proven all the different ways we're going to use it yet. So maybe there's not a lot of lawmaking yet that's been done around artificial intelligence. Well, in this instance, you would actually be incorrect because there has already been some regulation and some lawmaking already being done, and there's plenty more on the way around artificial intelligence. So let's talk about a couple of those specific regulatory laws that have passed and kind of where things are headed in terms of the regulatory landscape for artificial intelligence. So, the first piece of legislation that is having a huge impact in the way that AI is regulated is the European Union's Artificial Intelligence Act, or the EU AI Act. And it actually became effective in August of 2024. So, this is already current law. And there's a few different major pieces of this piece of legislation. So, it has a risk based framework, which is actually really excellent. It has some obligations, and then it puts in a bunch of requirements as well. And it spends a lot of time focused on what it calls high risk use cases of artificial intelligence. So let's talk a little bit about a couple of those components. The risk based framework for the EU AI Act creates four different categories of risk for artificial intelligence. There's a unacceptable risk. Those things are just not allowed. And then there's high risk, and then limited risk, and minimal risk. And this legislation spends most of its time focusing on the high risk use cases, and it describes and gives examples of what are some of those high risk use cases. It's worth touching upon, though, that first level, the unacceptable risk. So these are examples of things that are just purely prohibited in terms of the use of artificial intelligence. And an example in the actual law itself is social scoring. So this would be something that you've heard about coming out of China or those types of things where you basically take all this information about a person's individual history and their transaction activity, like how they voted and whether they pay their taxes and uh, how good they're participating in society and then credit and all these other kinds of things. And you create this score. And then that score is actually used to decide when they get access to governmental services and certain rights and when things kind of go easy for them and when they don't. Directly from the state. So that type of use is prohibited use of artificial intelligence according to the EU AI Act. What are some examples of high risk use cases? These are examples that include things that have pretty big impacts on people, like maybe they include personally identifiable information, maybe they include health information, maybe they include health outcomes, maybe they include financial outcomes. Those are examples of high risk use cases. So, use of artificial intelligence in a medical device, right? So, imagine that you have a device that attaches to your arm and maybe takes your blood sugar levels and kind of regulates the amount of insulin that you're being provided as a result of those levels. And it's theoretically using artificial intelligence in this situation. That would be considered a high risk use case. And since that involves somebody's health, perhaps it's easy to understand why that would be considered a high risk use case. Or how about an artificial intelligence that is involved in a applicant tracking system or human resources information system, and it kind of provides like a employee performance score or a candidate match score that can perhaps get factored in automated decisions about whether somebody gets hired or at least components of that decision, and maybe whether they get a raise or whether they even get fired. So those things have pretty material impacts for individuals. And so it's imaginable to understand why that might be considered a very high risk use case. So those classification levels are really nicely defined at a high level in the EU AI Act. And that's something that the Act is very good at. And then it describes some obligations, like, for example, You have to conduct conformity assessments. Are you conforming to the requirements in the law before you actually deploy the artificial intelligence? And you have to do a risk assessment, and you have to have risk management, so actual response to your risk assessment. And you have to have an ongoing life cycle of monitoring this. And that needs to be documented as well. It can't just be something that you say you're doing. You have to be able to show evidence that you're doing this. And then you have to maintain human oversight over these artificial intelligence systems so that someone can step in. And that's the type of thing that's referenced in some governance frameworks, such as the OECD governance framework or the blueprint for the AI Bill of Rights as well. So it's understandable where some of these kinds of sources and ideas are coming from. And those are all necessary for high risk uses of artificial intelligence. Additionally, the Act creates some requirements for transparency because we have to be able to explain how a decision was made, what factors were considered, what sorts of inputs are involved in these automated decisions. And if somebody wants to get some kind of recourse, they disagree, they want to contest the output, you need to have some level of transparency that allows to go in and see what was actually involved. So you can't just say this black box algorithm did it, the AI did it. You've got to be able to explain those things and then address those types of concerns with people. So that is the EU AI Act in a real quick nutshell. And that kind of gives you some flavor of where this sort of thing's headed. But just because there's new legislation being passed doesn't mean we can forget about the existing legislation that's already been in place and how that might apply to the use of artificial intelligence. For example, the General Data Protection Regulation, or GDPR, which deals with personal information for European Union citizens, still applies in the instance of artificial intelligence that is using personal information for individuals. And in the GDPR, there's already a number of requirements around transparency, and it describes the right to receive an explanation for how your personal information is being used. It establishes requirements for minimizing the amount of data that's collected and retained, and then establishes requirements for consent. Those people whose data is being used, they have to consent to their personal information being used. And then it sets up accountability requirements as well. So the GDPR was existing law that already has established these requirements, and now these requirements are in place for personal information that's being used for artificial intelligence. So that kind of gives an example of new legislation as well as existing legislation and how these things apply in the instance and how they're relevant to artificial intelligence. Now, we're talking a lot about Europe right now, but the United States is often not to be left behind, even though it takes a little bit longer to get some types of things done. And there is legislation coming out of California that will impact artificial intelligence as well. And organizations are already preparing for this type of thing. So the California Privacy Protection Agency, a regulatory authority in California, has established a draft of regulations on automated decision making technology, or ADMT. And in November of 2024, the CPPA board voted to go ahead and proceed with these regulations. So this is looking likely to become law. This is coming our way. It's even though it's not in effect yet. And that's why it's important to be able to understand how this is establishing requirements already for artificial intelligence, especially for organizations that find themselves covered by California law and the CPPA. So, a couple things that are included in this automated decision making technology regulation, or ADMT regulation, is that any technology that processes personal information and uses computation to make decisions or facilitate human decision making is covered by this law. So that, interestingly, can sound very broad, right? If it's using personal information to make automated decisions, right? Like using somebody's name and address and determine whether or not to include them in a marketing campaign or include them as a result of their credit history and provide certain types of credit allowances or trade credit to some type of individual. That can be interesting. Or leaving it open to include even the facilitation of human decision making starts to make it sound very broad as well. So we want to keep a nice close eye on this to understand just how pervasively this applies, because a lot of systems use personal information and facilitate decision making, right? If you think of analytics systems that are tracking like customer behavior and customer activity, and then we decide when to market and how to address these certain segments and how to include certain individuals in our promotions or not, or when to interact with them or when to reach out to them. These types of things may be facilitating a lot of decision making. So we'd want to make sure we understand how this ultimately is going to play out. So keeping a nice close eye on this. And within the draft, it establishes consumer rights, like the right to opt out of allowing the system to use your personal information, and the right to access and see what information is being held about you by this system. And then for the organizations, it establishes requirements for transparency and assessing the risk of these systems. So we're keeping a close eye on what's going on in California, and then also keeping a close eye on what's going on in Colorado. Colorado has made some news for being the first state to pass an artificial intelligence act in the United States. And this is forward looking, even though the legislation is already passed. It becomes effective in February of 2026, and it establishes some requirements at a high level. So, first of all, this Colorado AI Act defines a high risk AI system as one that, quote, when deployed, makes or is a substantial factor in making a consequential decision. So, any AI system that is going to be automating consequential decisions. And what could that be about? Well, it could be about uh, who receives what types of services, or whether or not someone is going to be extended services, or whether or not someone is going to receive certain eligibility for coverage for some type of maybe insurance or something like that. These could start to, I think you can imagine pretty quickly, can start to be a little bit controversial if they're used this way. So maybe it's a good thing that states are forward looking. The interesting aspect of this, though, is that if this is being done at the state level, you could end up with, just like in privacy regulation, a sort of patchwork of a bunch of different regulations that you need to consider and comply with when using this technology. And that makes it harder and more costly for organizations to comply with these regulations. So, in this type of environment, a state by state by state sort of approach can create additional challenges that perhaps could be avoided if there was some overarching guidance, perhaps at a federal level, but we'll see where that heads. In the Colorado AI Act, there is a focus on uh, the bias risk and discrimination and how these things must be avoided. And then also disclosure. You need to disclose when an AI system is being used. There's been some initial discussion in 2023 and 2024 about using AI chatbots, but maybe not necessarily disclosing that there's AI. I hear and read about different organizations having different thoughts and opinions on that. A lot of this legislation that's coming out is saying, well, you got to tell people when it's an AI system. You got to tell somebody when there's not a human being involved in this system and in this communication and that kind of thing. So, some of this legislation is giving us some informative guidance on how those decisions might need to head in the future. The Colorado AI Act also establishes a duty of care for developers, and not only the developers of, for example, these large models, but then also the deployers. Even if it was developed by some third party, if you deploy it, you still have a certain duty of care to avoid, for example, discrimination. So those are the kinds of things that are already in place and or coming very soon in terms of the regulation of artificial intelligence. And if this is the type of topic that you find interesting and important and that you want to learn more about, then this is a good resource for you to continue checking that out. So check out Vision.cpa or reach out to me, Rob at Vision.cpa. Love to keep the discussion going.